Hi everybody, welcome to Lecture 10 in History 414, 514, that is the Constitution and U.S. history. Today I'm going to be talking about Article 2 of the Constitution, the executive branch. In terms of the qualifications for president, the qualifications were lower than those for office holders in the states since there was no property requirement. And as you guys will remember from having read the Northwest Ordinance, there was a pretty substantial property qualification for the governor of the Northwest Territory. During the debate about the executive in the Constitutional Convention, Charles Pinckney of South Carolina proposed a $100,000 property qualification, and that would have been tantamount to $2 million in today's economy, but that idea was rejected. Another qualification for the president was that the president had to be 35 years of age. As your readings for this week suggest, this was to avoid the selection of a son of a president to become the next president. The idea of a political dynasty was very abhorrent to the framers, and normally by the time somebody got to be 35 years old, they would have made a name for themselves or reputation for themselves on their own account. If you look back at British history, the framers were not too far off with this because there were some times when political dynasties were perpetuated. For example, William Pitt the Elder and then William Pitt the Younger serving as prime minister, both of them in the 18th century. Another aspect of the qualifications for the choice of president, it had to be somebody who was a natural-born citizen, that is, somebody born in the United States, and you will have read in your annotated Citizens Constitution about some of the ways in which that particular qualification has challenged certain candidates and also completely prevented others. So, for example, you see Arnold Schwarzenegger here, former governor of California. He will never be president unless that natural-born citizen requirement were to be waived by amendment. As you guys know from last week, the Electoral College didn't really have anything to do with big state versus small state balance, but rather it had to do with fears about direct popular election by people unaware of the national picture, or direct election by Congress, which would cause the presidency to be just kind of like a puppet of Congress. States could allow for direct popular election of electors. Another reason for the Electoral College was that direct popular election would disfavor the slave states, but the Electoral College would count the slaves toward the population and thus the Electoral College. And what we see there is that the impact of the Electoral College is real. For example, Virginia got 6 more House seats than Pennsylvania under the first census, despite having 10% fewer free citizens and far fewer eligible voters. As a direct result, for 32 of the first 36 years of our nation's history, Virginians occupied the presidency. It used to be the case, as you will know by reading Article 2 of the Constitution, that the vice president was initially the runner-up for the president. So whoever got the most votes would be the president, and whoever got the second most would be vice president. This would have led to some really interesting pairings, especially in recent times, had it not been for the passage of the 12th Amendment. The 12th Amendment fixed the situation that occurred in 1800, whereby Thomas Jefferson and Aaron Burr, both of whom were Democratic Republicans, tied in the Electoral College, and then there were 36 votes in the House of Representatives before somebody finally abstained from voting, allowing Jefferson to be elected president. So the 12th Amendment changed the situation so that a vice president runs on the ticket with the president as a separate office. What are the powers of the presidency? Well, the president has the power to, as it says here, serve as commander-in-chief of the Army, the Navy, and federalized militias, or what we know of as the National Guard. The president can reprieve or pardon anyone, but only for federal crimes. People who commit state crimes are supposedly not within the reach of the presidential pardon. The president can make treaties along with 2/3 of the Senate, but can break treaties unilaterally and can appoint ambassadors and ministers. And ambassadorships are usually just kind of a present to political supporters rather than being chosen from people from the ranks of people who might actually know something about the country to which they are being sent. Thus, it makes sense why Callista Gingrich right now is the ambassador to the Vatican. Otherwise, an appointment that makes very little sense. The president also has the power to appoint Supreme Court justices with the advice and consent of the Senate. It's a little bit of a weird situation, though. I mean, Supreme Court justices can be torpedoed by the Senate refusing to allow them to become Supreme Court justices. But it's also the case that, as we saw in the nomination of Merrick Garland by President Obama in his last year of office, that the Senate could totally close down the appointment process by refusing to have a hearing on Garland. The president can make recess appointments, that is, appoint anybody to any position when Congress is not in session. The president can convene Congress, but can't dismiss Congress unless the two houses of Congress are having an issue with when they are going to dismiss themselves. The president gives a State of the Union address, and then finally he's supposed to take care that the laws be faithfully executed. There are various ways in which Article 2 attempted to restrain the executive. For example, the president could only be in charge of state militias when they were federalized. And as your chapter points out, the idea here was still, even in the post-constitutional period, that the state militias could serve as a kind of countervailing power to the federal army. The same federalism was at work when the president was prohibited from pardoning people for state crimes. And, of course, the most powerful check on the presidency was impeachment. What you see at left here is the Arkansas National Guard helping to desegregate the schools in Little Rock after, first of all, Governor Faubus used the National Guard to prevent the Little Rock Nine, that is 9 African-American students, from going to high school. Then Eisenhower stepped in and nationalized the Arkansas National Guard and then used them to make sure that those students were protected as they attempted to go to class. Impeachment was a new thing for executives. There wasn't any impeachment of kings under English law, but the founders understood the need for a restraining power in the case of a rogue executive because presidents could not be criminally prosecuted while in office. So impeachment is not a tool of criminal prosecution. It is a political tool. The sole power of impeachment lies with the House, impeachment being the bringing of charges. The sole power to try all impeachments, that is, hold a trial and possibly eject the president from office, lies with the Senate. The judiciary is also involved in terms of having the Chief Justice preside. This was supposed to be a nod to the solemnity of the occasion, and also because normally the Vice President presides over the Senate, and so you couldn't have that sort of conflict of interest. by having the vice president preside over the impeachment hearing if the vice president was then going to maybe become the president. What were the charges that could be brought? Well, these were for high crimes and misdemeanors, and treason and bribery were specifically mentioned in Article 2, but dereliction of duty, that is the failure of the president to do his duty properly, was also something that the founders worried about and wanted to be able to have impeachment for. So it didn't have to be a prosecutable offense. Dereliction of duty doesn't necessarily mean you get prosecuted for it, but if you go off and party someplace during a national emergency rather than serving as the president, that is certainly a dereliction of duty. At left there is George III, who the framers would have liked to impeach if they could have, but again, kings don't get impeached. One of the aspects of late 20th and 21st century history that's really interesting is the emergence of the theory of the unitary executive. This theory dates from the Reagan administration as part of Ronald Reagan's new approach toward governance. He believed in disassembling the administrative state that had been constructed during the New Deal. To do this, he and his Department of Justice asserted that as president, he had the right to shut down independent agencies and to fire longtime workers who were not committed to his policy positions. And at first, this was controversial, but then over time, with successive conservative presidents, so you had Reagan and then George H.W. Bush, and then Clinton, who was a very conservative Democrat, and then George W. Bush, you had the nurturing of this idea that the executive branch should be the most active and the most powerful, and Congress over time has diminished in its power and authority as a result. By the time of the George W. Bush administration, enough conservative thinkers had penetrated government for a new threshold to be established, that the president had the right not only to see that, quote, the laws were faithfully executed, but also that the Constitution was, so that the president, in a way, could decide what was constitutional and what wasn't, and also to attach signing statements to bills that listed things that the president disagreed with about the bills and that he didn't intend to do. So since the George W. Bush era, Republican administrations have really insisted on a unitary executive. And this can mean the removal of anybody who disagrees with the president. We've seen quite a lot of that in the present administration. Proponents of the unitary executive theory rely very much on Alexander Hamilton, who initially called for a president to serve on, quote, good behavior, which means for life. Hamilton was eventually convinced to moderate his view, but he still thought that a really empowered, strong executive was necessary in order for quick decision-making to happen, especially in an emergency. You invest one guy with all the power to make a decision, and it can be made quickly. And also the location of responsibility. In his view, it was easier for Americans to be able to identify who was responsible when things went poorly if there was one person in charge than if decision-making was distributed. That only works, though, when you have a president who is willing to accept that responsibility. And here is one such president at the right of the slide, Harry Truman, who was famous for saying, "The buck stops here with me." And so, he was willing to accept responsibility for his decisions. One of the weird blind spots of the Founding Fathers, Madison thought Americans would never elect a bad person to the presidency. He wrote, "If the government of any country on the face of earth was ever effectually guarded against the election of ambitious or designing characters to the first office of the state, I think it may with truth be said to be the case under the Constitution of the United States." So he really trusted Americans to have that virtue of being able to see a bad character and understand that it was a bad character and not elect that person to the presidency. People who are advocates of the unitary executive theory tend to be constitutional originalists. And this is a good time to talk about constitutional originalism. There are basically two schools of thought about the Constitution. One, that it is our job as interpreters of the Constitution to look only at the original meaning of the Constitution, whether that is the textual meaning or the original public meaning. And constitutional originalists go through a kind of subroutine where, first of all, they try to parse what the Constitution meant on a given issue by looking at the plain meaning of words at the time. They have to use words in context or look at dictionaries from the time to understand what those words would have meant to people at the time. Then they consult contemporaneous public statements about what the Constitution meant. And then if that doesn't clear it up, they look at private statements and letters and diaries and things. And then if that doesn't clear it up, then they look at actual practices around the time of the ratification of the Constitution. And supposedly, ever since the Reagan administration, the court has held this up as supposedly the right way to interpret the Constitution. But we have to ask why that is. I mean, after all, the Constitution was written in the 1780s. And people like Thomas Jefferson, who didn't participate in the writing of the Constitution, thought that it would be really terrible to bind future generations by the decisions of the framing generation. So the other school of thought about constitutional interpretation is, why should we not have a living constitution, a constitution that reflects the state of the world in the year that we're in rather than in 1789? I will say right now there seems to be a preponderance of people who call themselves originalists on the Supreme Court, but whether or not they really act as though they are coherently practicing original meanings readers across the Constitution, that is a very, very controversial question. One of the first originalists to really set out his approach toward the Constitution was Justice Antonin Scalia, now passed away, of course. But Scalia, if you read any of his opinions, was very, very indebted toward the framers for his attitudes about things, and had some surprisingly, I don't know, I was about to say Paleolithic attitudes about things. I'll leave it there. But he was kind of a backwards thinker. The problems with the unitary executive theory. Well, first of all, contestation about how the presidency would work in practice started immediately after ratification. For example, Washington in 1793 proclaimed neutrality because there was a war happening between Britain and France. The United States had signed a treaty of amity and commerce with the French in 1778. Theoretically, we were still bound by that treaty, but Washington took it upon himself to proclaim neutrality in the war, thus abrogating that treaty. And so the idea that there should be a unitary executive was kind of destabilizing from the start. Second of all, if you look at the powers that were given to state governors in this time period, state governors whose jobs were sort of like that of president had to work within the boundary of what state legislatures allowed them to do. They didn't have a huge amount of power. And so if you fail to look at the context of states, you may get an idea that the federal executive should have much more power than is probably the case. And then finally, if you agree with the unitary executive theory, then you can have this whipsawing of national goals depending on who comes into office. So a president can come into office and, for reasons of his own, try to undo everything done by his predecessor. Whereas if you invest more power in Congress, there tends to be less of that. You will get a new president at the outside every 8 years, but you normally don't get an entire turnover of Congress every 8 years. So there you go. That is the unitary executive theory. It is one of the interesting things about Article 2 of the Constitution, and hopefully something that we can discuss in the discussion section. So see you in the discussion.